duty to act with integrity, fidelity, and in good faith, which means you need to work with disinterested skill, zeal, and diligence, and primarily for the benefit of the public. In other words, the benefit that you should not be seeking to pursue is your own. As you sit up there, you need to be pursuing the benefit of the public, the constituency you represent here, the residents of the Community Services District. Your duties include also, under the Community Services District law, to exercise your independent judgment to further the purposes and intent of the Community Services District law and represent the interests of the entire district, not the interests of any residents in your respective divisions. Obviously, we are at-large elections, so that would not necessarily pertain, but it is important to remember that you represent the interests of the entire district, all of the constituents within the district. Under this Community Services District law, the board's role is to establish policies for the operation of the district and provide for the implementation of the policies. The implementation of the policies is the role of the general manager, and this is set forth in the Community Services District law. And a member of the board cannot be the general manager, the treasurer, or any other compensated employee of the district. We don't have volunteer firefighters here to my knowledge, so we need not worry about that. We have an obligation to elect officers of the board and do so annually. And it sets forth the roles of the president and the vice president, and you have, of course, more particular procedures and policies that detail this. Are there any questions so far before I move on?
I do have one comment.
Sure.
In item B under the ethical duties, and it discusses even the issue of being elected by divisions or from divisions. And you mentioned rightly so that we're at large. Recent law is discussing districts having to leave the at-large and go into districts. Is this an appropriate time just to touch on that issue for the board members?
Sure, I can touch on that issue. I'm actually intimately familiar with the issue of at-large versus by district or from district elections, as you may have guessed. The at-large question is one of whether all
You're talking about the city of Palmdale?
I'm talking about the city of Palmdale. I'm talking about and then allegations were also made with regard to whether the city of Lancaster needed to go to by district or from district. And so an analysis was done, and that issue was determined by one of the preeminent experts on the Voting Rights Act that Lancaster did not need to go to by district elections. But in any event, the issue is one of whether all protected classes are represented by at-large elected officials if there's particularly racial minorities. And in some cities, it usually comes up in cities and school districts is where this issue has arisen most recently. The question becomes whether a community that may have a large minority population, it's not a majority, it is a minority population, but enough that one would expect the occasional election of a person, an official from that particular group to occur, and it hasn't. And so that raises the question of whether the voting rights of all individuals within that community are being protected. And so the question is, are the officials of choice, or the candidates of choice of a minority group being elected to office? And I do not know the history of the racial makeup either of Rosamond Community Services District, a constituency, or press members of the board. An evaluation of policies. Operations are delegated to professional staff members of the district. And then the policy also kind of goes, corollaries of that are the next few bullet points. Directors individually do not instruct management or staff on how to implement policies or programs or the day-to-day operations. If approached by district personnel regarding district policy, those inquiries should be directed to the supervisor and or the general manager. Chain of command needs to be followed. Requests for information, of course, are appropriate and should be channeled through the general manager. And if you don't get it from the general manager, then it is appropriate to go to the subordinate staff. And of course, the board of directors has gets its power from votes of a majority of the board of directors. No individual director has the ability to establish policy. Okay, ethical training. Did you have any questions about the breakdown of the roles of the board versus staff, general manager, before I jump on to AB 1234 training? Hearing none. Ethical training is required in order for everyone who receives compensation, salary, stipend, or reimbursement. And that training is 2 hours of training every 2 years. The great thing about this training is it is easy to do. Yes?
Two questions. One is, to take the training, it counts for both the RMAC and the RCSD, I would imagine.
Yes.
Yeah, you don't have to do it twice.
Okay.
Because it would be silly, because it would be the same training.
And given your definition, though, the RMAC, nobody on the RMAC receives any compensation, salary, or stipend.
Do they get reimbursed?
I'm never been aware of anybody asking for reimbursement.
Then you probably don't have to do it.
If there is a provision in your bylaws for reimbursement, then it would cause
Right.
that to be done.
Right. I have one client where the board does not take any compensation or reimbursement, and that's part of their rules, and they do not have to do 1234 training.
Oh.
So, but
It's easy to
most boards, even if they don't get reimbursement, I mean, don't get stipends or salary or payment of compensation, even if they don't pay themselves for going to meetings and things like that, they get reimbursement when they travel. Most boards do that.
And they're allowed to get reimbursement when they travel, but I never heard of anybody ever asking for that.
Right, but if they're allowed to, then you need to do 1234 training.
They offer that at conferences sometimes, don't they?
They'll offer it at your conferences that you attend, as well as Secretary of State has ethical training.
Yeah.
And one of the issues with that is if you take that, make sure that you stay on the training the entire 2 hours.
Yes.
Because if you go 1 hour and 55 minutes, you won't get credit.
Yes, but it's on the Secretary of State's website. It's a web-based presentation. It takes 2 hours, but it's right there. It's free. It's simple. It's just a matter of doing it.
Well, I took it at the conference last time.
Oh, then you're set.
Those you get certificates for.
If you finish early, you can always
Did they send them
give you an extra.
for me? They did. Should have been 2, right?
Any questions about 1234? Okay, moving on to conflicts of interest. Conflicts of interest are governed by the government code at 87-100 and by the regulations by the FPPC in the 18,000 series. And there's an 8-step analysis that is sort of laid out here in this outline, and it's how you perform the analysis to decide if there is a conflict that would require disqualification. So the first question is the individual a public official? You are. Moving on. So is a public official, when you're talking about decisions you make here. If you're making a decision some other aspect of your life, that's a different question. But in this room, you're a public official. Is the public official participating in making, or influencing a governmental decision? Generally speaking, when you're here, you are. Which is why there's not a lot of discussion under steps 1 and 2. Okay, then the next question becomes, does the official have one of the 6 qualifying types of economic interest? And they're laid out there. It's businesses, property, sources of income, sources of gifts, personal finances, and positions in organizations.
Okay.
With regard to positions in organizations, this is one that people get concerned about regularly, and I want to make sure you understand. The officer, director, employee of a nonprofit is not an economic interest. Okay, so if your church is a nonprofit,
It is.
and if it were in some way before this board for something, that would not be an economic interest. You would not have a conflict.
The Rosamond Foundation would not be a conflict.
It is not a conflict, correct, because it is a 501c3. So that's one that comes up a lot. Positions and organizations, people get a little freaked out about that, thinking that their charitable works are going to conflict them out of things with regard to their elected position, and it does not. So that's, and then this business entities, real property, sources of income, gifts, personal finances, real quick descriptions are there for what the thresholds are for interests in those various types of economic
I have a
functions.
question. On sources of income, any person from whom he has received income of $500 or more within 12 months prior to the decision in question.
Yes.
Okay. If there's no, I'm trying to think of how to word this question. As you know, I'm a reserve deputy sheriff, all right? And you and I have talked about this. There's nothing that would come before this board that has anything to do with the association.
The Sheriff's Association?
Yes.
Right. So I suspect you will not have a conflict on that basis.
Okay.
You still need to disclose it on your Form 700.
That was the question.
Yes, it is still a disclosable interest. You need to disclose that on your Form 700, and Form 700s are going to come up in a minute. But that's your statement of economic interest. It's due by April 1st. I believe Lizette has emailed you all about it with the forms. You can do it online in this county, I think? No? No? Okay. You get the forms online, but you can't fill them out online? Okay. They've all at PPC to get their advice on whether, and you can also write a letter and ask for an actual opinion about whether you have a conflict. And the emails actually are pretty promptly responded to. And then you have a piece of paper that makes you feel nice and comfortable.
And a rule of thumb, if it's sprung on you, you know, it wasn't anticipated for some reason, if in doubt,
Walk out.
step out.
Yeah.
Yeah.
You are much safer to have recused yourself when you didn't need to than to vote on something when you are unsure. Okay, and then the next step is, will the decision have a material or financial effect on your interest? So you may have an interest, but it's not material. Materiality is assumed if it's directly involved, and so for example, let's say for example the economic interest, if one of you had a business, let's say, well this would be a 1090 violation too, but let's say Director Landsgaard's law firm was going to have an arrangement to provide legal services to the district. First of all, it would be a 1090 violation and it would be a criminal act. Second of all, that would be a direct involvement. An indirect involvement is more remote. It's a situation where your financial interest would be impacted by the decision, but it is not the direct subject of the decision. So then there are thresholds that are set forth in the regulations. They are very long and very complicated, and I will very much walk you through them if you find yourself in need. But retyping them here, it wasn't terribly productive. So does anyone have any questions about how you decide what's direct or indirect, and then once you decide that, then you go to materiality thresholds if it's indirect.
Like the church gives me my fishing license every year, I don't have to report that, right?
They give you a fishing license?
They give me $60 to buy it.
$60 is below the threshold. You need
Yeah, I know, but if it comes up over, then you report it, right?
Yes. Yes.
Do all members of your church get that?
So you might want to join this church.
That's what I'm talking about.
Well, I bought a lifetime now.
Okay.
Got a question on the source of gifts.
Yes,
Before it was 440, now has it gone up to 460?
yes. Okay, so then the next question is whether it's reasonably foreseeable that the interest will be materially affected. Is there a substantial likelihood that there will be a material effect on your financial interest? If there is, then we move on to step 7. This is where the public generally exception comes in. If that effect is indistinguishable from the effect on the rest of the community, so for example, you guys are setting rates, right? We would have gotten all the way through all of this because you all have property interests in which you would be affected by the rate. You're all elected officials. You would be making the decision. It will be directly involved. Will it have a material effect? Yes. Is it reasonably foreseeable that it will be materially affected? Yes. Is the decision distinguishable from the effect on the general public? No. And that's where you would stop in the analysis. That's where the public general exception comes in. But if we don't have you participate, we cannot make the decision. That's when we do the rule of necessity. We draw straws, and 2 of you would step out of the room, and 1 of you would vote. Yes.
What if you have 3 members in a meeting?
You cannot vote on under rule of necessity with only 3 members in a meeting.
Well,
Unless you've already selected the necessary party. But you cannot declare a rule of necessity based on absences.
okay.
Okay? If you could get to, if there is a way you could get to 3 qualified board members who are not conflicted without the rule of necessity, you must wait and do it at another meeting. You cannot use absences to override a conflict. You can only use, absences do not necessity make, as I guess the easiest way to put it. You've got to use non-conflicted members first. Any conflict, you need to declare your conflict. Leave the room. You cannot attempt to influence the decision inside the room, outside the room, except you may, if you declare your conflict and step down from the dais, you may speak as a member of the public from the podium.
And then leave the room?
You cannot, you should leave the room. It is safer, and I recommend against speaking from the podium because people in the audience tend to not understand that it is okay, and it tends to rile people up. I've seen it done a couple times. It's always ugly. I recommend against it unless it is, for some reason, really necessary for you to do it. But and that's not legal advice, that's political advice. But legally you may. Announce your conflict, step down from the dais, speak from the podium, and then move out of the way. Okay. Any questions about conflicts under the FPPC rules? Okay. Next we have 1090. This is 1090 is the big dog in the that's the legal term for it in the conflicts of interest world, and that is that an officer or employee cannot make a contract in which you are financially interested. So you cannot participate in any stage of a process by which a contract is planned, negotiated, or executed.
This includes employees of the district as well?
It includes management level employees.
Okay.
You cannot cure a 1090 violation by abstaining from voting. So, for example, that's what when I said if Director Landsgaard's firm was going to contract with the district for legal services, it would be a 1090 violation. That's him contracting as a district board member with himself. That would be improper. If you have, if you have a business, you cannot have that business contract with the district.
Agreed. So we can't have, yes, regional patrols, still around, he could, runs a contract for the, even if he stepped out of the room, he's still gonna have a contract with his security permit.
Absolutely not, under no circumstances. Yeah. Yeah.
And if Al wanted to rent this room for a church gathering, he couldn't do that either. He could not enter a contract.
If he takes a salary from his church, then he could not. If it's just by virtue of if he sits on the board of the church only and it's a nonprofit, then he could, because it's not a financial interest. Okay? So it would depend on the facts and circumstances. But if he takes a salary, he has an economic interest by virtue of that salary. It's a source of income.
Okay, but on the same token, if he wanted to rent this place, he could have somebody from his church come in and make the application? I was gonna say recluse himself, so he wasn't open.
You just can't do it all, period. Okay, basically, the district property's off limits to all 5 of those things.
On 1090. All right, so 1099 is incompatible offices. You cannot simultaneously hold 2 offices that are incompatible. They are incompatible if one exercises supervisory power over the other. There's a possibility of a significant clash of duties or loyalties based on similar jurisdictions, or other public policy considerations make it improper. Worth noting that the RMAC, a Municipal Advisory Commission, is expressly stated in the Community Services District law to not be an incompatible office with membership on the Board of Directors of the Service District. So that is not an incompatible office, and since I know we've got one here, I thought I'd mention it.
The public school would be.
It very well could be, yes, because especially in current situation where we are contracting with one another, it would be.
The groundwater litigation, I think they're also litigating for the water too. So
yeah, I think it's, I would probably come down that it is an incompatible office. And the rule is that you forfeit the first office when you take the second. So, okay, then the next is incompatible activities, and that's essentially you can't proceed with any enterprise, employment, activity that is incompatible with or in conflict with or inimical to your official duties or the functions or responsibilities of the authority. That is essentially, I'll give an example, not my client, but I'm fully aware of it. There is a situation in a city in the state of California in which a member of I'm going to say elective body to keep it as generic as possible, has appeared as attorney of record for the plaintiff suing the public body on which this person sits as an elected official. That is an incompatible activity. You cannot sue yourself. That is an incompatible. So Olaf, you can't sue. You can't sue the district. Yes, I am not kidding.
Did you see the recent case where the woman is suing herself for killing her husband in a car crash?
Yeah.
I did not.
Yes.
That's awesome.
I think it was going to the Supreme Court, wasn't it?
Yeah.
She's suing herself
To get that.
to get the insurance money?
To get the insurance money.
Guess
For
who's
the
fighting
kids.
that?
I guess if she passed.
And unless there are questions about incompatible activities. Okay. And then there's the common law doctrine against conflicts of interest, and that's where there's no statutory and no 1090, but there is a non-financial personal interest that would inure benefit to you that would violate your obligation to use your disinterested skill, zeal, and diligence for the benefit of the public. And basically it goes back to, would you be perceived as making the decision based on the benefit of the public or on the benefit to you in this other capacity? It doesn't come up a lot. But it is an underlying premise that we want public officials to be making their decisions based upon the interests of the public, not their self-interest.
What happened in Clark versus City of Hermosa Beach?
Hermosa Beach, I will have to look at it and get back to you, Olaf. There are a number of cases in here, and I'm not sure which one that is.
Okay.
So. All right. The Brown Act. We've been through a lot of these recently, but and you all seem to be grasping all of the requirements with regard to meetings, but I'm going to just run through it quickly. The board cannot make a decision even without voting, so reaching a consensus or otherwise demonstrating a decision, even if not overtly voted, anywhere but at a noticed and agendized meeting. It can be a regular, special, or emergency meeting, and the requirements for the posting are set forth under item C. Quickly, it's 72 hours for a regular, 24 hours for a special, and emergency is 1 hour. And emergency is really and truly emergency. It's earthquake, it's flood, fire, famine, locusts. It's
It's related to health and safety.
Health and safety.
In our
Yes, of this district. So for example, if somebody bombed the water treatment, I mean, it would be, there was an earthquake and there was a shear of the pipelines and we needed to provide for emergency water trucking in order to get water to the people. That would be an emergency situation where it would be appropriate to call an emergency meeting, and we would do it, assuming we had a place to do it. Also, there are also provisions for emergencies where, you know, it's suddenly unsafe to have the meeting in the location where it was scheduled. It can be adjourned to another location. I've had that happen where there was a bomb threat on the location where the meeting was to occur. You can move it to parking lot. You can move it wherever you need to move it. But you announce it and you go where you need to go. So the Brown Act does not require you to engage in unsafe behaviors. Consensus about a matter that will come before the district. They can talk about, for example, let's say they voted 3-2 to change the symbol to a pink fluffy bunny, right? 3 of them could then stand there and say, I think that was the best decision ever. That's fine. Or they could stand there and argue about, you know, you guys are crazy. Why a pink fluffy bunny? Why not a giraffe? You know, that is fine. They're not reaching consensus. They're not, but they cannot stand there and try and persuade one another to bring it back, right, and revote. That would be improper. So you can.
Because during that engagement, they can technically come to a consensus.
They could. It's dangerous.
Not allowing the public the opportunity
Correct.
to listen.
Should they? Is it safe to have those conversations? No.
So is it proper for me to step in if I see any of it happening and say, we can't do this, and wait for the next meeting?
You can. I frequently do.
Okay.
I consider that my role.
But
If I see it, if I'm not there, then
just to safeguard.
yes. And
we can't discuss this here.
the way I tend to do it is I say, please remember the Brown Act. I
Okay.
don't know what you're talking about precisely, but remember the Brown Act. You can't reach a consensus here. If you need me to agendize something, please let me know.
Because it can be very easy to.
It can quickly slip.
The Brown Act, a lot of the Brown Act actually, and the reasons for not doing this or that is perception. And
Yes.
perception can lead to the same actions as an actual violation. And that's why most of the time we're advised not to have those type of sidebar conversations or
Right.
off-site conversations of that nature.
Right. It can quickly devolve into consensus building if one is not careful, which is why my recommendation is usually 2, no more. 2. And if you don't have more than 2, then you can't have a blind or brown act violation, unless you're wheeling.
And I appreciate you keeping us on track. I want you to know that.
And I have been called Mother Teresa by several clients for walking up and saying, and please don't be offended if I do it, I'm not accusing you of anything, I'm trying to protect you.
And I heard Ed say earlier for you to make sure you're doing what was right. So thank you.
No problem. Closed session items, there are very specific safe harbor provisions about what needs to be on the agenda for closed session. I work with staff to make sure we meet those. And then for special meetings, we can only talk about the things that are on the agenda, like today. We're talking only about this policy, or these provisions. I'm giving you an update. We're not reaching a consensus on anything else. The topics that can be discussed in closed session are set forth in here: personnel, pending litigation, or anticipated litigation, real property negotiations, labor negotiations, public security, and license applications.
License applications?
That's what the Brown Act allows. You don't have license applications, but that's what the Brown Act allows.
I had somebody ask me if a member of the public can put something on the agenda. They can, right?
They can request it
Request it?
in advance. Under our policies, the way it works is they can request it at a board meeting, and then a director can ask that it be included, or they can submit it in writing in advance, and then in the general manager's discretion, if it is an appropriate item to be included on the agenda, it will go on, and if the member of the public disagrees with the general manager's decision, that individual can come to the board meeting and ask that it be added to the next agenda. So that's how it works under the policies that.
And if they ask at the next meeting, then it's up to the president or what?
It's up to the directors, any one of them can put it on.
The, when it says the next meeting, that's the one that bothers me. It's the next available meeting.
We can.
It's trying to say everything that comes up, we're gonna do it on the next meeting. No. We will do it on a meeting, but it may not be for a month or 6 weeks.
That would be a good thing to bring up in our next policy workshop,
You know,
if you'd like to see that change, but that's not what we're
I would like to
doing
see
today.
that change, because otherwise you have a lengthy agenda. And all the training that I've had, says consistently, if your regular meeting, not a workshop like this, but if your regular meeting goes beyond about an hour and a half or 2 hours, there's a problem. And the problem is the directors. That's what I've heard. But maybe the problem is too much on the agenda. And that's why, you know, if 5 people in the public wanted something on the next agenda, it could mean, and we wanted to sit up here and discuss it, you know, 45 minutes for every item.
I guess the question is.
Remember, we can't reach a consensus on this because we're not here for workshopping the policies,
Yeah.
but,
Well, I guess on the other hand, if it's something important to the public, you should at least start the dialogue, and you can always table something in a meeting. What's wrong with that?
we'll take this up at the next policy workshop. Because we're gonna get if one more director speaks, we are going to find ourselves in a Brown Act violation situation, so I got it on my list of things for the next policy meeting. Information, you cannot require people to sign in. They're entitled to provide testimony. You can establish regulations to assist in processing comments, so you can set time limits. You can, per person, you can set time limits by item. You can set, and it is important that if you're going to do a time limit by item, that you do it prior to beginning the item and you announce it. Yes?
If a person doesn't state who they are, but you actually know who they are, is that something that the board secretary can reflect in the minutes?
Yes, there's nothing wrong with reflecting that in the minutes if the board secretary knows who that person is. But we can't mandate that people write down who they are or state their identity, yes.
No, usually if they don't state their name, and I wasn't able to identify them, I put down whatever the public said.
That's fine. That's fine.
But if it's something that she doesn't know that we know, you tell her.
Yeah, you could, but remember, the minutes don't have to reflect what the public said. They only need to reflect the
I
action.
guess what I'm saying is they don't enjoy an anonymity when they take the mic.
No more than they otherwise would have, because people do or do not know who they are.
Okay.
And it's important to remember that when someone is speaking at the podium, we cannot prohibit them from criticizing our policies, procedures, or programs, or the acts or omissions of the members of the legislative body. So we can't, if someone comes up here and starts berating one director, we cannot require them to, we can't prohibit them from speaking based on the content. If they're threatening someone, that's a different question. But if they are merely criticizing a director, all directors, a policy, give them their 5 minutes, and be done.
Yeah, that has been a portion of recent case law, and a city was held to answer on that, and were found guilty of preventing the speech. I can't remember what the penalty was.
We said at training, who was that with, last speaker? And he said that they could talk about anything they want to talk about.
Yep.
For 5 minutes.
Well, as long as it pertains to the business of the district.
Well, he said anything, he said he could talk about their car or anything.
It is dangerous to try and decide what pertains to the business of the district. It is, in my opinion, far better to let them have their 5 minutes, say thank you,
And Steve said,
let them sit down.
Steve said something that was good, said, he told us during that time, he said, we don't have to respond, or should respond.
In public comments, you should not.
No, you should not.
In fact, that is, in the response is really walking a fine line, because in a response, it basically can enlist a back and forth discussion.
And it can result in consensus, because if you respond, I think you're full of it, and the rest of you go, you just got yourself a consensus.
And they can say anything they want about you, right?
For no reason.
I mean, they can't threaten you.
Anything they can back up.
Yeah. But during director's comments, you can speak to your position on it. So you can say, I would like to clear my name with regard to this, and then say whatever it is you have to say. Don't engage though. Okay? Don't engage in the back and forth.
Gotcha.
Okay? All right. Okay.
By extension, Counselor, does that, sounds to me healthy opinion, does that extend to the public talking about issues within the district, criticizing directors on YouTube, in the Rosamond News?
I'm not sure what your question is. Can they do that?
Yes, can they do it?
Sure.
First of all, and then, what action is the board prohibited from in retaliating against them?
Criminal acts, they're definitely prohibited from criminal acts. They're prohibited from having a meeting of 3 of them to discuss how they're going to respond without it being agendized.
And certainly not in closed session.
Unless it's threatened litigation or pertains to a personnel matter.
To initiate litigation?
Initiation of litigation is a closed session item, yes. That's appropriate.
Over an item such as this?
I'm not sure what such as this you're referring to.
A statement made by a public person at the podium or in the press or on YouTube.
And the board's going to retaliate against them.
Correct.
Well, and I would say that
Not retaliation.
it's not. it has to be something that is legally, that can be brought before a court, and that's why we have a court. The court will decide the question, basically, whether or not this is legal or justified or sustained or not. And I think that's where you come with that.
Well, we're talking about a person coming to the podium in a public meeting and expressing their opinion about an issue or about some director's vote. And you're saying that the board can't silence them.
It's true.
Okay, now by extension, if they...
Based on content. Yeah, we can't.
Yeah, okay, but by extension, if they say the same thing in the press or on YouTube...
It doesn't implicate the Brown Act at all.
No, we're not talking about the Brown Act. We're talking about retaliation for what they said publicly.
In my mind, it's not retaliation.
Lawful public discourse is fine. I'm sorry, but I'm not.
If I go to the podium, and I make a statement that's offensive to the board or to the general manager,
Right.
they can't say, John, sit down and shut up, or leave the room.
As long as if you are criticizing them or the policies of the district.
Yes.
No.
All right, now, well, stop there. Then by extension, if I take exactly the same thing that I said at the podium and send a letter to the editor in the Rosamond News, or allow a reporter from the Rosamond News to interview me, and I say exactly the same thing, can the board take action to suppress that or discourage me from doing that or make it hard for me to do that? Same words, take the same words that I said at the podium.
Right, but what we're talking about at the podium is protected by the Brown Act. What you do outside the meeting has no Brown Act protections. So that it would depend on the precise facts and circumstances, and I'm not going to give legal advice based on...
No, but you're evading the real issue because...
No, I'm not. I'm telling you, I'm not going to give you legal advice.
Yeah, you're asking for legal advice.
I'm
No.
not going to give you legal advice based on complete hypothetical. No, I'm not going to do it.
I'm not asking for legal advice.
Okay?
I'm saying if we took exactly the same words that is said in a public meeting, it's not a Brown Act issue. We're not talking about the Brown Act here.
But that's what we're talking about here.
Yeah,
That's where the protection of the content
I would say this.
exists.
The extension of the comments made in a meeting to outside of a meeting, there is no extension.
Right.
Because the meeting rules governed by the Brown Act are very specific to that engagement. Anything said outside of that are subject to public comment in public. And some of the things that govern what you can do and what you can say and how you can act in public are slander, defamation, a crime, as the penal code governs it. Those are types of things that would answer your question to the outside. Are they this? Are they that? If someone should think they are, it's within their First Amendment right to seek redress. And that gives that the ability to be decided before a court. And that's what my comment was. A court would decide whether or not, yes, it is in fact this or that.
But if a person at the podium made a slanderous remark, it sounds to me like you're saying you could not sue them.
That's right.
The board cannot sue them. Even though they made a remark that was untrue, that was deliberately meant to slander. Is that what I'm hearing?
I think even if you make that, I think slander is not protected by the Brown Act. Although you cannot stymie speech at the podium, it doesn't, it's moot
It doesn't
on whether or not it is violating some other law. So I don't think your assumption is correct that the Brown Act protects all speech. It is moot on whether or not it's slander, defamation, or something else.
Right. The fact that the board can't prevent criticism has no bearing on whether the speech itself is actionable.
There you go. That's what I meant.
Okay. Any other questions from the board? We get you all, an informal vote from you on whether to do X, Y, or Z. I cannot call Dennis, then Olaf, then Ed, then Al, then Byron, and get your votes.
It's what you'd expect to do in Congress or in.
Correct. You cannot do here.
Yeah.
We did what you did in Congress, we go to jail.
And emailing each other regarding current issues under your jurisdiction violates the Brown Act. If you email all of you, even if you send them to the secretary, post them on the website, and report them. That's why occasionally you will see me, if informational item is shared among the board members, you will see me. If I'm sending you an information item, you will almost never see me, you should not ever see me ask you to respond back to me. If I email all of you, if I'm sending an information item to you, I may do that. You'll see it at the bottom of the page, but I cannot solicit your input back. I can send information out. There can be a one-way communication, but I cannot solicit your input back. So if I see information going out to the board as a whole from someone, I will, if I am copied on it, you will frequently see a, please remember the Brown Act and do not hit reply all to that email from me to all of you. That is why I do it. I'm not saying there was a Brown Act violation. I am trying to prevent one. Okay? And please don't be offended if I ever do that to you. It is not a critique. It is a reminder so that we don't find ourselves having to announce a Brown Act violation.
I think it's probably easier to say when you respond to an email, don't reply to all unless you absolutely have to reply to all.
Yes.
And that will resolve that issue.
Right. And, like, for example, emailing everyone to find their availability to attend a meeting is not a Brown Act violation. That is fine. That is logistics. That is setting up the meeting. You are fine. Getting into how one will vote on the matter to be considered at that meeting, that's a Brown Act violation if it's circulated among everyone and people are replying all and everyone is discussing the issue in email form. That is still a Brown Act violation. If an item is not on the agenda and is not added to the agenda under the provisions permitted, you cannot take action or discuss an item that's not on the agenda except to briefly respond to statements or questions posed under public comment. You can ask a question for clarification, make a brief announcement or a report on your own activities, and you can refer direct staff to report back at a subsequent meeting regarding a matter or action, or ask that something will be placed on the agenda. That is absolutely appropriate. You can attend special events. The majority may, you may attend conferences and other things like that without it being deemed a meeting, so long as you don't take a majority of you and reach a consensus regarding a matter pertaining to the district. If you reach a consensus about where to go to dinner, that's fine. But you cannot reach a consensus regarding any matters pertaining to the district. So
I went to our MAC meeting, there was 2 directors already there, so I left.
okay. Actually, meetings of other governmental bodies, you may attend. You may participate on the items listed on the agenda of that body. You may not bring up district issues, like, for example, during public comment and get consensus from your board members during public comment at RMAC.
Even if there's already 2 there?
Yeah, yeah, that is one of the exceptions.
So I can go.
You can go, yes.
The other thing is too, if you're at a function, a social function or something like that, because there's 2 there, you don't have to leave. you can be there. It's just not discussing any business of the district.
Right.
The other thing is, if for some reason you're in a particular meeting of some sort or gathering of some sort, that the three of you come together and appear to be discussing business, that's a perception issue that I mentioned before, that here's where the Brown Act comes up. So you're left having to explain yourself or having to answer to a prospective Brown Act violation.
Right.
So that's the difference in that.
You can all three go to, you can have 3 of you or 5 of you all go to, you know, an Elks meeting and discuss Elks business and vote on Elks things.
You probably don't all 5 want to be seated at the same table, or even 3 at the same table if you can help it. Spread it out.
Because you're likely to find yourselves talking about district business. It just happens. I would encourage you to try and stay in groups of 2, no more, if you can. It's not, you don't have to. You are allowed to sit and talk about the weather and your respective families and your churches and all of those things. You are allowed to be social. Just be careful.
Well, in my experience, when the wives are there with the directors, it stifles all the conversation.
But like if I go to our night meeting, and Ole usually gives a report about
RCSD.
yes, and it's once in a while he'll ask me a question, is that all right? About
Well, you're the only one there.
The only other one there, you're fine. If there are 3 of you there, don't pull both of you.
But you can more.
You can have one speak, yeah. Okay. If a Brown Act violation has occurred, it can be cured. And the way you cure it is you announce it at a meeting and you revote on whatever the issue is.
It's called a do-over.
Yeah, it's a do-over. And if that came to my attention, I would recommend that it be done. And you announce it, you redo, and you're done.
Well, if you announce it and you say we're not going to redo that, we're actually going to change that, what happens?
I'm sorry. You revote. You don't have to revote the same way.
If you revote and it goes a different way, then it's
Then the second vote is the
binding vote.
binding vote. Yeah.
Specifically, you brought up to the board on the 24th of November that we had violated the Brown Act because of the subsection. So what we did, because we had a special meeting coming up, we tabled that vote to the next meeting in order to take it up properly and correct the problem.
And that's a cure.
Right.
If it was handled properly, which it wasn't. The other question though, if there was another Brown Act violation that occurred on, say, March 26th, 2014,
Okay.
where there was only 3 board members present and they voted 2 to 1 on an item, what do you do with that? If we want to take it back on a revote, we could actually revote that.
Yeah.
We could do that?
You can revote it. You can revote it. You can bring an item back up at any time. There may be no practical of bringing an item back up, but you can bring an item back up. You know, it depends on what the item is. But
There are a couple items actually from that meeting, but one was an emergency meeting item, the other one was an item was 2 to 1 vote.
okay, I don't know what item you're talking about, or multiple items you're talking about.
You can bring that back up, any item, and re-vote it again.
Yeah, whether there's a Brown Act violation or not, you can revote items anytime. They may not have any practical effect, but
Let me
it
ask you
can
a
be done,
question
yeah.
this way here. Who can, say there's a vote 3 to 2,
Uh-huh.
okay? Can the people that voted against it have it brought back, but somebody that voted for it can bring it back?
That's not a Brown Act issue, though.
I
That's a
understand
Robert's
that,
Rules
but
issue.
no, no.
Yes, the winning, any of the voters on the winning side can bring something back. The winning side of the vote. So if it was a 3 to 2 vote in favor, then one of the 3 can bring it back. But that's not a Brown Act. That's Robert's Rules. Okay.
But we were talking about bringing it back, so I wanted to get that
Yeah.
clarified.
No, that's
So,
okay. Any other questions?
I have one more. don't mean to pester you, Counselor, and not asking for legal counsel, except that, what about larger issues of corruption, financial corruption, misreporting? That's not a votable item. Where does an appeal from the public go in that case?
Can go to the district attorney, can go to the grand jury, can go to the state attorney general. Depends on the thing. What?
FPPC?
FPPC, yeah. Depends on the thing.
Thank you.
Any further?